Okay, want to welcome you to the last session of the day, which is to sum up all the regional breakouts that we just had. I'm Ron Reinstein, retired or semi-retired judge from Arizona. Just want to introduce you to the other facilitators here from the various regions. On my far left is Martha Bashford, who is an assistant DA for the New York County District Attorney's Office in New York. Next is Christine Cole, who is the executive director of the program in criminal justice at Harvard University, the Kennedy School of Government in Cambridge. Next is Mary Lou Leary, who you've already met, the executive director of the National Center for Victims of Crime in D.C. Cable Cropper is here, and Cable came in as a replacement for nobody. Oh, yeah, we had to add him as well. Woody Clark, who is a judge, former prosecutor in San Diego, now a judge in San Diego County, California. Ken Melson, director of the Executive Office for the United States Attorneys in D.C. Jules Epstein, who you've already heard from, who is a professor at Widener in Delaware. And Mark Smith, who is taking Carol Henderson's spot, who you already heard has the flu. Mark is the executive director of the Center for American and International Law in Plano, Texas, a suburb of Dallas. First of all, I understand that there were some issues regarding the purposes of the solicitation, and just wanted to read you what NIJ is seeking applications for from states wishing to receive funding to help defray the costs associated with post-conviction DNA testing of forcible rape, murder, and non-negligent manslaughter cases, so that's the field, in which actual innocence might be demonstrated. And the funds can be used to review such post-conviction cases and to locate and analyze biological evidence that's associated with those cases. And the other thing is that the purposes of the announcement have to do with the case review definition means review of files or documentation of post-conviction cases of forcible rape, murder, and non-negligent manslaughter by appropriate persons such as prosecutors, public defenders, law enforcement personnel, and medical examiners in order to determine whether biological evidence may exist that might, through DNA analysis, demonstrate actual innocence. Another definition was locate evidence, and that was really an issue in the group that I facilitated, means to locate, following a case review, biological evidence that through DNA analysis might demonstrate actual innocence through activities such as the searching of files, storage facilities, and evidence rooms. And finally, the definition of DNA analysis of biological evidence includes the handling, screening, and DNA analysis of biological evidence located in connection with the case review. And all analysis conducted using funding from the program must be performed by a laboratory that's either government-owned or fee-for-service that is accredited, and it currently undergoes external audits not less than once every 2 years that demonstrate compliance with the DNA quality assurance standards established by the director of the FBI. So with that, we're going to have reports out, and we're going to start with Martha, who had Region 1, which was the great states of Maine, Vermont, Massachusetts, Rhode Island, and Connecticut. And as we go through here, if there's any questions regarding that came up regarding the solicitation, the application process, and the like, we've got Robin Jones and Chuck Hoyrick out here from NIJ who will serve as resources for those issues. Martha.
We had the best food. We met outside. I think all the rest of you were stuck indoors. It was also interesting because we had a large contingent from Massachusetts, which is one of the 4 states without a post-conviction DNA testing statute. But as we compared experiences, it seemed that the states that did have the statutes, a lot of people sort of do an end run, a cooperative phone call, and let's look into this case. Despite the existence of a statute, and Massachusetts seems to be able to handle it in a cooperative manner as well. One of the big issues, and it's been talked about here over the past 2 days, is evidence retention. Who's going to pay for it? What is evidence? Is it just the rape kit, or is it the seat of the car on which a rape occurred? How long do you keep it? As DNA testing becomes more prevalent with crimes such as burglaries, and depending on a person's record, they can wind up doing more time on some of these cases than on a manslaughter. Do you keep it for all cases? We recognized only a small amount of convicted offenders will ever ask for testing. Is there some way of winnowing down what you keep and how long? We didn't have any answers to it. Some people thought perhaps in connection with a plea, that a plea could be final, that you could waive preservation of evidence. Funding for every dollar spent on evidence retention is a dollar not spent on health care or some other thing from the state. In general, about the conference in general, people really enjoyed having a chance to speak with each other at this breakout session. Generally, when you go to conferences, I'm with prosecutors, defense attorneys are with defense attorneys, lab people are with lab people, and it was very nice chance to sit and talk about these problems in a multidisciplinary way. And the thought was if they could do this again in a regional basis, that the people from Maine, what happens in California was not terribly pertinent to them, but in a sort of a regional basis, and you can see how people close to you are dealing with the same issues would be very helpful.
And Chuck, do you care whether we do it in order, or can we just go left to right here? Christine, you had Region 5, which was the Midwestern states of Illinois, Indiana, Kentucky, which has one of the grants, Ohio and Wisconsin.
That's right, thanks. I'd love for the group to stand up and take a bow because they did great work.
No fights.
We had some good discussion, but no punches were thrown and no evidence collected. Our conversation, we had a great cross-section of the sectors, I think, with maybe a preponderance from what I would say the prosecutor's side, because there were investigators, someone from appeals, and an assistant attorney general, assistant district attorney. I think our conversation came down into three main areas. One was a lot about the solicitation. As you mentioned, Ron, Kentucky was in our group, so we used them as a resource. We talked about the solicitation. We had long conversations about evidence collection, storage, preservation, and destruction. And then the third area we talked about was sort of working together, working as collaborators. As we talked about the solicitation, there were lots of questions around the purpose, the use of the money, implementation, restrictions on spending, and such. So thank you for what you read about what NIJ is seeking to fund. Mike Shepo visited our group, and he left and came back with some information too, that the past solicitation is going to be on the website. So I think that that's important for people to know, to use as a resource, and also that some of the proposals that were funded will end up on the website for other people to look at. So thanks to Mike for scurrying around and getting answers for us that he didn't have at the top of his head. The second area, not unlike Region 1, is we talked a lot about evidence. We talked about the importance of increasing the quality of collection in the first instance. That collecting something and collecting good evidence is going to be really important. It's as bad as just destroying it before you need it. We talked a lot about storage, preservation, the before trial, and then locating it and finding its condition and its storage post-trial, and that the various locations it's going to be in, clerk's offices, courthouses, police departments, labs, just being able to get your handle on finding it, what it is, and then the quality of it. And we talked a lot about who's supposed to do that, whose role is it, which got us talking about a desire for requirements or standards or best practices around retention and preservation. And we heard that IACP has some models, and that there's the Scientific Working Group that has some models, and American Academy of Forensic Sciences has models. And we found that knowing that, though that's nice, that wasn't really helpful to our group, because we wanted some suggestions for having it in one place, pardon me, and ways that each aspect or each sector of the criminal justice system is doing similar kind of standards. So we talked a little bit about recommending a cross-sector working group to review and refine existing models and maybe make some recommendations that takes into consideration all of the different ones. We also talked about that there was a desire for shared decision-making by, I'll call government, law enforcement, and the prosecutor with the defense on retention and destruction. And some would suggest it's worth trying, and some suggested it'll never happen. But the bottom line is there's a desire for equal access to information as early as possible about what we have, what's been collected, what's going to be tested, so there can be shared decision-making around what's going to be kept and what might be destroyed. And then a really, I think, important point was made is that we've got to separate past evidence from future evidence, things that were used at trial and things that might be used post-conviction. And then the third category, I've loosely lumped together as working with each other or working with collaborators. This was mostly from the lab folks, but how difficult it is to manage current work and roles with additional new requirements. We talked about, it's my phrase, but I said there are outliers, positive and negative, in every sector. Because we talked about how some people have had an epiphany or an enlightenment based on good experiences, and some people are less interested in being part of a collaborative work. So we've got good and bad in every part of the sector that we work in. And then compensation, how important it is to think about compensation for the exonerees, that there's a difference between mistakes made and malice, and just that yet either way, for whatever reason, we've got an exoneration, that there's a lack of public confidence, or it affects public confidence in the system, and how important it is to do community relations relative to that. And finally, particularly notable because of his absence today of Dwayne Dale, that the reentry methods and supports for exonerees has really failed, and something needs to happen about that.
Thanks.
Thanks.
And Mary Lou went kind of west with the states of Alaska, Washington, Oregon, and Nevada, which was Region 7.
Was that you or me? Sorry. In our group, we talked about some themes in common with the first two groups. We talked about collaboration, screening, a variety of issues around labs, both public and private labs, integrity and retention of evidence, and resources. On the issue of collaboration, there was a lot of interesting back and forth. We had a great group, very participatory. And everybody, I think, in principle, agrees that some kind of collaboration, some kind of collaborative approach to these issues can be very helpful. But you have to identify your common ground. You know, what would it take to make a collaboration succeed? Identify your common ground. Get real. Acknowledge that we have different roles, different interests, and come from different places in the system. And those differences have to be acknowledged, and you have to have some hard conversations to get beyond the knee-jerk, oh, you slimy defense attorney, oh, you Nazi prosecutor kind of thing. You just have to have some hard conversations and just get it out there. Sometimes it helps to be focused on work outside a specific case where your adversarial instincts really come to play, working more along the lines of policy and protocol. People point out honesty and humility are really important if you are going to be able to work together. And again, like Marcia's group, a lot of informal cooperation goes on. And folks talked about, for instance, how they just will call the prosecutor and lay things out and work something out completely quietly and behind the scenes to get testing. Legislative issues for our group, sunset clause, the requirement of trial before you can get DNA testing, they were issues. And the screening process was something that people talked a lot about, because this can be so overwhelming when you just get hundreds of cases and you have to deal with them. And some of the folks in my group, the court basically, if you're in prison and you send the judge a letter and say, I want to get this evidence tested, he basically just stamps it and appoints counsel. And so these lawyers, and they don't have an Innocence Project, are just overwhelmed with these cases, and there's no mechanism to kind of filter any of them out up front. And so people talked about how you can set up a successful screening process. Issues with private labs, and what are the requirements? We were lucky we had 2 lab people who were incredibly knowledgeable, who knew all about it and gave us all the scoop on what you have to be certified or an acceptable lab. Evidence integrity and evidence retention. The integrity was kind of interesting, and there was some discussion about how evidence takes on a life of its own from the time that it's produced. And then it's collected, and there's chain of custody, and then you go through the trial. And by the time you get to post-conviction, this evidence has really been around the block a few times and can oftentimes be compromised. And so that's an issue to look out for. And the last issue was resources that are required for all of these things. Evidence retention is just huge, absolutely huge. And there's some talk about how hopefully technology's changing, and so you won't necessarily have to keep every piece of evidence. You can keep samples and so on. But it is a huge issue, and it's going to require a lot of hard choices to be made, and many resources. And of course, people are looking to NIJ to provide resources for evidence retention as well.
Okay, thanks, Mary Lou. I forgot to mention for Cable that he's the executive director of the National Criminal Justice Association in D.C., and he had the great states of Texas, Oklahoma, Louisiana, and actually the best state, Arizona.
Thank you. Our group was very spirited, had a good discussion. We spent most of our time talking about issues around evidence retention and destruction, using the Arizona legislation really as sort of a case study in that regard. Essentially, the legislation was passed through a coalition of people working together to get this legislation enacted. And even though it provides some statewide parameters and foundation, I think the group was in agreement that it doesn't solve all the problem, but it does provide a platform on which to work. Some of the issues that came up during the passage of the legislation and continues on is the time limits. How long do you keep evidence? What kinds of statutes of limitation? What kinds of cases, and how long do you keep the statute of limitations as it applies to the type of case? I talked a lot about inconsistent retention policies by local law enforcement, that even though the statute requests policies from local law enforcement, there's no kind of training or support in implementing or even enforcing those policies, which comes down to also a resource issue. One of the issues that came up in the discussion that I thought was kind of interesting, because I hadn't heard it before, was the issue of retaining evidence at the end of sentences. That I think that some people think that at the end of, once the sentence is served, then evidence can be destroyed. It's brought up that in case of sex offenders, where there's a registration requirement following the completion of a sentence, that evidence can also be important in terms of that offender being required to be on lifetime registration. And a particular case was discussed in that regard. The other issue that came up in terms of retention of evidence was that there was a couple members of the group that felt very strongly that evidence should not be destroyed on a plea bargain, because the underlying charge could become important later. The other issue that the group spent a lot of time with, and actually continued to talk about it after the 2:30 termination of the session, was the access and the use of the state, local, and CODIS databases. It was evident that there was a lot of confusion or uncertainty about who had access and what could you actually expect from a search on one of these databases, and what's the process to get access to the database. And I think it's an issue of clarifying policies from jurisdiction to jurisdiction within one state, as well as training for all those involved in trying to get information. But as I said, the discussion continued past the 2:30 cutoff time. I think it was, for me, it was a very enlightening, very valuable discussion.
And I had Region 3, which was Maryland, the District of Columbia, West Virginia, and Virginia. And the first thing that we started talking about, which was one that we heard yesterday from Betty Lane Desportes, was regarding the challenge in applying for the grant as to the fact that it's a cooperative agreement versus a grant in itself. And I really, frankly, didn't understand. And I think that maybe either Chuck or Robin can just kind of give you a resource as to what to look to for that. They thought that there are certain things that their legislatures might have a problem with as far as federal, strings with federal dollars and the like. And the other thing they talked about regarding a problem with that was the changes in their own jurisdictions from administration to administration. So I don't know, Chuck, if you wanted to address this whole issue regarding cooperative agreement versus grant as to where they can look for a resource, not to explain it and go into it today.
The best place for everybody to look would be at the website of the Office of Justice Programs, and in our financial guide, it gives a very clear breakdown of what the difference is between a grant and a cooperative agreement. And in a nutshell, it's really just the level of involvement that the government has with whoever is getting the award money, but that's the best resource for getting caught up on what the differences are between those two.
Okay, thanks. The other thing that came up regarding that was somebody expressed some issue regarding the difficulty in getting specific memorandums of understanding with other agencies or offices within the state to facilitate the review process and getting access to the information. And I was mentioning that has not been a problem, I know, in our state, but evidently it is seen as a problem in some other jurisdictions within a particular state. We spent a lot of time talking about cataloging, storage, and preservation issues. The problem regarding the lab information management systems, they talked about the need for barcoding, not going forward, but as to the old stuff that's in those warehouses that we saw in some of the pictures, and feel that most people thought that was a huge problem. Some people felt that really that the grant for post-conviction missed the step because of the fact of this storage issue and being able to go back and this massive problem that they see, particularly in urban areas, of going through warehouses, property rooms, and the like. And we talked about the need for standardization within the states, but then some people felt that there should be standardization nationally, and that's really important, and then leave enough flexibility within the states to adapt, but the national standards or guidelines were really important regarding cataloging and storage. Some people felt that it might be helpful to have a technical working group, a twig regarding such issues on warehousing and standardization for handling evidence. But the issue was the huge amount of old evidence that there is in these cases, and that storage is a major issue, particularly for law enforcement and the laboratories. We also talked about the fact of lack of resources, particularly in the major urban areas, for preservation, and that resources, of course, is going to be an issue in a lot of these areas, but preservation was a huge issue for lack of resources. We got into the issue regarding whether anybody had any problems with CODIS or other databases which have hindered post-conviction investigation. Most people didn't have a problem with that. We got into the area about their opinion about defense access to CODIS and granting requests from the defense, and the people at the laboratory seemed to feel that that was not a significant issue, that if the request was made and that if it was probative, that they would, be able to honor the request and make the entry. Of course, they've got the requirements that they'd have to meet with NDIS as well. But then the other side of that is what's really probative. When you've got an entire car, when you've got an entire back seat of a car, you've got an entire door, you've got a bed sheet, and what evidence are you going to save? What evidence are you going to have tested? Just the same issues that law enforcement has with laboratories as to prioritization and any kind of limitation of the evidence that's being examined, because there are only so many resources that we have and so many scientists and lab analysts to do the work. We got into the issue about victim notification system, and that seems to be determined by the individual case. We talked about the experience that Jennifer Thompson Canino had yesterday, where she had a lot of trust in the detective that worked on her case, and he was on it for forever. Well, you know, he was probably the appropriate one in that particular case. Some jurisdictions, some victims will have more contact with an advocate, but everybody agreed that the thing that really should happen is that the law enforcement officers should be working closely with the victim advocates or victim representatives within the particular jurisdiction, and that the worst thing that could happen is that somebody reads something in the newspaper, hears about it on TV, and that a victim would get information that way. But that there should be a system in place within a particular jurisdiction. We talked a little bit about compensation, and there was kind of a split in that. Some people felt that there should be a uniform statute nationally regarding compensation. Other ones felt it should be left to the states. There was, I think, maybe some disagreement as to whether or not you're better off doing a lawsuit, if possible, but that 1983 actions are difficult in the federal courts, or whether to have compensation, but that it's not fair for somebody in one state to walk out with nothing, or $25,000 total for serving 15 years in prison, and in another state somebody gets $50,000 a year or whatever it is. We heard about Dwayne Dale. He got, I think, $20,000 a year for each of the 18 or 19 years that he spent in prison. We talked about a little bit about future issues that could be addressed. One thing that came up with was the issue of statute of limitations, and one person felt that there really should be a national standard to do away with statute of limitations in homicide and sex offenses in particular. And I think that you know, we all agreed that that's something that's really done state to state, but there could be some leadership in that area as well. And I know a lot of the states don't have statute of limitations anymore on those type of offenses. And we also talked about just what they learned overarching, you know, as far as what could go forward, and that's more education regarding the reliability or lack of reliability of confessions, handling guilty pleas where there's false confessions and the like. So, next we had Region 6, Woody Clark, and Woody had a compendium, a lot of poopery of potpourri of states. Iowa, Kansas, Minnesota, Missouri, Michigan, Nebraska, South Dakota, Colorado, Idaho, Montana, Utah, Wyoming. You know, Robin and Chuck must have thought that, you know, Woody's really, he can handle them all.
Actually, I thought it was a little bit unusual for a San Diegan to be leading the discussion in the coldest part of the United States. But I finally figured out it was because of a football connection. We ranged from the winless Detroit Lions in Michigan to the undefeated and perhaps top-ranked Running Utes of the University of Utah. So that was clearly the connection. I will mention that, well, actually, before I mention that we talked about, our group had 2 states, Montana and South Dakota, that do not have a post-conviction statute, but the rest of the states, I believe, do. But I think one of our highlights was early on when one of our members mentioned that her first DNA case involved bear DNA. And I had to ask her, I assume it was a grizzly case. Sorry. I'm going to see if I can't just hit the highlights of what hasn't already been mentioned. In particular, what was that? I missed it. Oh, okay.
That was a highlight?
You may like my notes, by the way. I use the butcher block method that Ken Melson pointed out is not particularly a green approach. So I guess my carbon footprint needs to be improved. One of the issues we brought up was related to searching profiles. And in some of the jurisdiction, there's apparently an automatic search. Once that foreign profile in a post-conviction DNA case is obtained, that fairly automatically, that's run against the national database system versus other jurisdictions that we dealt with. It appears to be sort of a discretionary act. One of the most important areas was the standard for obtaining post-conviction relief, and we discussed, you know, is that question answered at the outset, which under most statutes I think is correct, whether or not it fits within the particular standard of that individual state's post-conviction method. And we kind of talked about sort of the two basic standards, if you will. Some states require a showing that if these results were exclusionary or exculpatory, helpful to the defense, would it demonstrate actual innocence? Or in some of the other statutes, particularly those that have followed the model of either Illinois and New York originally in their original statutes, or from the model statute that was recommended by the National Commission on the Future of DNA Evidence, is there a reasonable probability that the outcome would have been different? And I think we recognize those are different standards, at least legally worded they're different standards, but I think we had at least a sentiment that perhaps the reasonable probability standard makes more sense, because it's an established standard. That is, the term reasonable probability is well rooted in the legal system, particularly in the area of ineffective assistance of counsel and the decisions whether or not that's established in a particular case, and perhaps that's a better standard to use than the actual innocence standard. So we spent a good deal of time talking about that. Thank you, Vanna. We talked about evidence preservation, and perhaps it would behoove all of us if a best practices standard or best practices recommendations were made, whether from the National Institute of Justice, or I know there's been work, as has been mentioned by IACP and other law enforcement organizations regarding that preservation, but its role obviously is critical. We also discussed, and as has already been mentioned, the absence today of one of our speakers is, do people who've even been exonerated, truly exonerated, actually end up wearing a scarlet letter as a result of that, and its impacts on them personally as well as on our society as well. So that was a very interesting discussion, I think. As far as post-conviction motions, does someone get an attorney immediately if they file a written motion or a letter to the court, letter to the district attorney's office asking for relief in post-conviction testing? Should they get a lawyer right at the outset? And I think that's a very good question. If they get a lawyer, shouldn't it be someone qualified with knowledge of the specific statute, knowledge of DNA and the possibilities or the likelihood of a technology, a specific technology, providing probative results? And then a very good suggestion about the importance of training in this area for attorneys who will not only attorneys dealing with these issues, but judges as well, Ron. You and me. Also, perhaps a system could be developed to look at these and examine these motions that isn't based just on attorneys and judges, perhaps a multidisciplinary board or a group of people to look at these motions and perhaps make decisions about whether or not testing is appropriate. I think that's a more significant departure from certainly the systems that we have in place. But it was also recognized of the need for advocates for these inmates. In other words, particularly in these cases where individuals have been in prison for some extended period of time, and they're still in prison, they may have written a letter, but do they need more than that? That could perhaps be solved by attorneys being appointed at the outset or by some other approaches as well. And then lastly, we had a good discussion fairly late in the process about officers, training of officers, which we do have resources for obviously already, so that these issues involving what types of evidence to collect, and in particular preservation, can be dealt with at the outset with a view towards what's going to happen in 20 or 30 years. And perhaps our technologies will change by that time as well, but we have to anticipate those changes and make sure that we do learn from the lessons of the past instead of repeating the mistakes that we've learned over the last period of decades.
Okay.
Thanks, Vanna.
Ken? We had Region 2, which was New York, Pennsylvania, New Jersey, and Jules' state of Delaware, or adopted state.
Yes, we did. And thank you. I don't have any grisly stories to tell you, but I hope you'll bear with me anyhow as we go through this. That's not bad. I get one too, okay? All right. I did have those 4 states, and although they're geographically very close to each other, their processes and issues and statutes were very diverse. And we found that even though we went in finding out that New York Innocence Project people came over to New Jersey to do some of those cases, and New Jersey hired all the Pennsylvania forensic scientists who were good because they could pay more than Pennsylvania, I think we all came out as friends, nevertheless, after our discussion. The statutes, we had a side-by-side comparison of the 4 statutes that I put together for them, and it was interesting to show the differences between the statutes. New York, which was passed originally in 1994, is not very involved at all. It says very little. It doesn't give a lot of direction, whereas if you look at Pennsylvania and New Jersey, which were both passed in 2002 and somewhat appear to be modeled on each other, was much more, they both were very much more involved. And I would suggest that they're both good statutes for the defense and the prosecution to look at, because it almost provides a checklist for what should be in a motion to answer a lot of the questions that the judge may ask on one of these cases, and for the defense and for the prosecution when they're perhaps drafting the order for the court to sign, because it puts a lot of protections in that process. So I thought those statutes were interesting. The place where the various states were in their Innocence Project type of efforts varied a lot too. Delaware was like a love fest. Everybody was just getting along well with each other. They had someone there from who was running the hospital evidence collection. They had SANE nurses. They had the lab there. They had the public defender there. Everybody but the prosecution. Apparently, they weren't interested in participating. Whereas Pennsylvania was just trying to stand up their Innocence Project efforts. So we had someone on both sides of the spectrum, with New York, of course, with a lot of experience, being the home of the Innocence Project, kind of in the middle there, still working on things. One of the practical effects that the prosecutors brought up was the stress on the resources of the prosecution, not because of the motions themselves or the subsequent efforts to get exoneration after the DNA has been tested, but because defense attorneys try to stretch the DNA post-conviction process into a process of bootstrapping up arguments that were otherwise time-barred under their other statutes. So they would try to pull those other issues in through the DNA testing, and it caused a lot of extraneous and excess litigation that should have been avoided. Also, the comment was that some of the judges didn't necessarily follow the restrictions in the statutes, with the feeling, I guess, that it's better just to go ahead and grant it and we'll figure it out after that. Whereas if you followed some of the restrictions that were put in the statutes, a lot of these issues could be resolved ahead of time and therefore save a lot of post-testing litigation. One of the other things that was said with respect to the process and getting our prosecution and lawyers and other stakeholders involved was the respect that you show for each other. And it was very pointed that the representative of the New York State Police Laboratory System was very pointed in saying that their relationship with the Innocence Project was just so tremendous, because when the Innocence Project in New York was at a case, they weren't there to slap down the prosecutor. They were there to work to do justice, and therefore that encouraged everybody in the system to work together. So that was an example, I think, of how if you work collaboratively and work with each other, showing mutual respect for each person's role in the process, that a lot more can get done. The number one issue is an issue that has already been addressed a couple times here, and that was the property rooms and the ability to find property that's in those rooms and the storage of the property in those rooms as well. It was interesting because we had some of the IACP chiefs in our breakout group, and they observed that it's not just an issue of money or an issue of standards, but you've got thousands and thousands of police departments, ranging from 2 or 3 man police departments who may keep evidence in their desk drawer to huge departments that are just completely overwhelmed. So it's a very, very huge project that they have to work on. One of the things that we kind of went off on after that was, well, what happens with the property once it's introduced into evidence? A number of the jurisdictions, their practice is to get the evidence back right away from the court, which resolves the issue of how the court stores well or not so well the evidence after conviction, but gets us back into the original problem of when that evidence is returned to the police department, it's probably worse off than it was staying in the clerk's desk drawer. in the courthouse. The other issue we talked about a little bit with respect to property is whether the crime lab can keep the evidence that is examined, at least, so that we know where it is and we can re-examine it later. New York City does that, apparently, but now they've been overwhelmed with the number of samples that they have, and they can't keep it, so they have to turn it back to the police department, and they're back into the same old problem with whether they can find the evidence or not. There was a consensus, at least in 2 of the states, that the exoneration cases were going to dry up. It was interesting that Delaware had gone through many of their cases, and Pennsylvania, after their statute was passed, got a lot of petitions, but they've been through all those petitions now, and there was somewhat of a view that these types of cases wouldn't exist for very many more years, despite some commentators and law reviews that suggest for other reasons they will continue even after we get through the backlog of previous cases. And there is one article out there that I have, if you're interested, that does talk about that. But one of the things that was pointed out in addition to that is maybe if this is the case and they are drying up, we shouldn't put our money into post-conviction. We ought to put it into pretrial testing of our DNA, because in that particular state, they're losing employees. They can't retain them because New Jersey hires them all the time. And so they need money for pretrial testing. If you get it tested ahead of time, then you're not going to have perhaps the issues afterwards. So that's where the money should go, perhaps. One of the issues we talked about was the requirement in one of these state statutes that all the testing on post-conviction cases has to be done by an accredited lab. And of course, that led into the discussion of whether or not we would put the profiles into CODIS after a profile is developed in a post-conviction case. The sentiment among many of the lab people there and the prosecutors is, why wouldn't you use an accredited lab? And if you do that and you get a profile that meets the CODIS requirements, there wouldn't be any reason why these laboratories, at least, wouldn't put their evidence through the CODIS process. So I think those were the primary issues that we had. It was a great group, and I asked them to applaud themselves afterwards for coming here and participating in this collaborative process between prosecutors and defense attorneys and the Innocence Project. You know, there wasn't too many years ago that you would never get these people to talk together with each other. I think it's commendable that you're all here doing that today, along with the laboratory personnel and the police. Thank you.
Sounds like you got a lot done, Ken. Ken is probably one of the most organized people that I know. Jules, they naturally picked you for the Deep South.
We got along just fine, thank you.
Jules had Region 4, which was Florida, Georgia, Mississippi, North Carolina, South Carolina, and Tennessee.
All right, and I will truly try not to repeat. Big issue, evidence preservation. I should back up. Tremendously impressed at how so many of the states I had the pleasure of meeting with and learning from have a very well-respected state labs. In other words, all the players say, we're okay with the state labs, we like them, we all work together, and I find that just a tremendous advance in things that have gone on over the years, and in many of the states, a true collaborative model. I'm going to come back to that because it's clear it's not everywhere, and one of the urgings is that there be more convocations such as this to present more and more models of successful collaborations, hoping that that will filter down. Evidence, evidence, evidence. So let me just read a bunch of bullet points. Making sure, this was from the labs, that people requesting testing and the like follow the regulations so that things are done in a uniform way. Following the regs or statutes so that all the players are indeed preserving evidence. Following up, again, a request for a best practices recommendation series on evidence preservation, and recognizing in particular that when the state lab does the testing, they've got a nice system. They've got an in system and an out system. And then it goes somewhere to some small police department somewhere or some small prosecutor's office or court system, and the system of evidence tracking and preservation breaks down. In terms of destruction, people felt, yeah, we need a rational destruction of evidence policy. And again, where the players, the different stakeholders come together to help formulate it. And then we need to know when it's really implemented. And if somebody says something is destroyed, especially if they say it was destroyed before this policy got implemented, that they've really done a due diligence check so that when they say it's destroyed, we can rely on that. Talked about labs saving extracts, and a request for grants. Where are the people with the wallets here, okay? That grants are needed for local labs and local police for their evidence preservation. And with that, money to inventory the old items. We talked about labs or departments that may have 2,000 or 3,000 evidence envelopes or whatever, and they don't have the money to barcode those and formalize a way to track them, which goes back to addressing the concerns for post-conviction. Then we talked some law and had some very interesting discussions. People heard me say earlier today, do the test and then figure out where you are. Because until we know, we may not be able to really answer the question, what does it mean? How significant is it? And an important point was raised is that nobody should get whipsawed. That if you agree to do the test as a prosecutor, that should not be misread or misargued as, aha, that means you've agreed that if it comes back with X result, my guy is exonerated. That they are two different questions, and that if we're going to have this collaborative model, people have to play it straight and say, if I'm asking for A, I'm asking for A, and I'm not going to try and bend the rules and say, aha, that's conclusive on issue B. We talked about, different standards of probativeness versus absolute exclusion. And one of the things we talked about, and it seems pretty clear, that this remains a problem, that many of the cases that we're looking at were tried from the defense side ineffectively. And that should be remembered, if you will, as a filter when you're looking at a case to say, might it deserve post-conviction testing? Don't presume that the case was tried a state of the art, so that you're not saying, well, the lawyer did A, B, and C, and therefore we only have to evaluate, well, maybe A, B, and C were wrong or insufficient. And so again, it's much more of let's have a bit of an open perspective. In terms of collaboration, as I said, a strong feeling that some places have the collaboration, some places are, well, we've got communication, which means on a one-on-one case, yeah, I can call somebody, there's somebody to listen to me, but that's different from a systems collaboration, and that has to be encouraged. We need more work on the model, and a very important point, which is please bring lab people in at the early stages when we're designing this I see a lab person nodding her head aggressively, yes, but bring lab people in early to help structure and inform the collaboration. I think much the way Dean's talk yesterday said, here are all these things you'd better be thinking about as the world of unintended consequences proceeds. So that's our report.
Okay, thanks, George. And I want to thank Mark for stepping in for Carol again. He had the island states of Hawaii and the Northern Mariana Islands, as well as the great state of California. And I just want to put a plug in for Mark. If any of you are aware of the program that he runs at the Center for American and International Law, some of us have participated in it. Jules and everybody's talked about collaboration. They run a program called Actual Innocence, Establishing Innocence and Guilt, every year, I believe, and it's for prosecutors, defense attorneys, and judges. I think it's co-sponsored by the Texas Court of Criminal Appeals, and it's really a very good educational training program for everybody involved in the system. Mark?
Thank you for the plug, Ron. On the theory that great minds tend to think alike, what we discussed resonates really pretty well with much of what we've heard from the other groups at the table. The buzzwords were collaboration and cooperation, and there was a sense that it's important to build from this meeting and go back to our home states and home regions and continue to meet on a regional basis to share ideas and to make sure that we're talking with one another on a continuing basis. The notion was that familiarity breeds agreement rather than contempt, and that we need to get past issues of turf protection. There was also a sense that we should do cross-training and that there should be joint training. We should work together to bring people into the same room, teach the science, especially on scientific issues, and to endorse what's been said by at least a couple of others. We suggest the creation of an NIJ working group on evidence retention, and specifically one geared to identifying best practices, model policies. And they're especially important at the front end to get all of the players around the table, the scientists, law enforcement, prosecution, defense, and judges. It was suggested, and I think well said, that we need to recognize that we all own this problem. And one plea that we heard was that we not take for granted the funding for innocence projects, that some are facing very difficult financial times. We had a couple of recommendations for the NIJ folks. One, this was from the great state of California, is that California is awfully big, and it would be nice if it didn't have to be a state application. We also think it's really important to make special efforts to get the word out about this upcoming grant application period. And if possible, to expand the window to give people as much time as possible from getting notice till the time that the applications have to be in. And since my comments, I think, Ron, are all that stand between the audience and the end of this session, I'm done.
Oh, I vote for him.
Well, I think Chuck or Robin's going to get the last word, but is there anybody that has any questions or comments about any of the things that were just discussed from any of the groups? Anything at all? Well, thank you. Well, Chuck, did you want to come forward to do the closing here? You want us to stay up here?
Thanks to Ron for moderating and to all the facilitators for doing a fantastic job. As I moved around from room to room briefly, I noticed that there was a lot of interaction and a lot of discussion, and that's exactly what we had planned and hoped would happen, that you felt comfortable enough in your groups and regions that you could talk about the issues that were challenging you in your states, and hopeful resolutions that you might be able to work on together, not only in your state but between states, with suggestions and ideas. A couple of housekeeping items before I close everything out. Don't forget to turn your evaluation forms in. These are very, very important to us as we continue to hear requests during the past 2 days that we might need to hold some more of these. Your comments would be very useful to us in the case that we are able to do so and structure another one or more of these events. as was mentioned earlier, and Ron read some of the solicitation, you will be getting an email from Jocelyn Williams in the next couple days after you return home, and it will have a link to the 2008 post-conviction solicitation, as well as an attached PDF copy of it for your review. So you will have a sense of what the solicitation is about and its contents, and there will be some minor changes as it goes through the review process for the next round, which I said earlier is we're hopeful will be out at the end of February, beginning of March. Now, one thing you can do is you can go to grants.gov and put in a email notification that you can get based on different programs that you're interested in. So it's my understanding that if you go there and you're interested in post-conviction, you can sign up to get a notification as to when any type of grant that involves post-conviction, DNA testing, or other types of testing hits the streets. And then you will get an email. You'll know that it's out there and it's out for people to start applying for. You'll also get another email from Jocelyn once the video and the PowerPoints are available, but don't hesitate to check in 6 or 7 days as well at the URL that we have on the back of your program. With all of that being said, I would like to thank you all for attending. I would like to thank all the people that helped us put this together, especially, again, Robin Jones, Jocelyn Williams, and Margaret Black, who helped me pull this off when we were told to do it on October 5th and invite 300 people and have it done in January. And I think we did it. Hopefully you're taking home some information, contacts, and tools that will help you not only work on post-conviction assistance in your state, but equip you to submit applications for future grant opportunities. My contact information is in the book, as the other Department of Justice NIJ people. If you have any questions, if you have any suggestions, don't hesitate to call us. With that being said, enjoy your evening, have safe travels, and we hope to see you soon. Thank you.